Please, may I? Please. The point that I'm perhaps trying to make, and which is what I'm trying to draw the court's attention to, is that the Nalsar judgment that they placed reliance upon extensively, there is a plus and there is perhaps a downside to it. The plus is that judgment must be read in its context. And the issue was the recognition of a third gender. That was what it was limited itself to. And therefore, to extrapolate the findings of the particular judgment, which primarily concerned itself with self-perception, self-identification in the context of gender identity, to extend it to a marital transaction or a marriage-like transaction is to read a judgment for what it is not. Secondly, there are only 3 in cases.
I think we perhaps are aware of how to read these judgments.
Please.
We don't need to be taught.
No, Millets, I'm sorry. I understand. I'm just placing reliance on this. I'm just making
Yes, we understand that these are contexts.
Please.
Whether they're analogies or not is up to us.
My lords, please, Millets. I'm grateful. The second point is, in fact, on a closer reading of this particular judgment, certain inconsistencies emerge between the 2 opinions of the very same bench in terms of what constitutes sexual orientation, what constitutes gender identity. Now, that is natural because there is a discussion that's going on there. It is not to be read in the same manner as a statute. In fact, therefore, the judgment, which doesn't exactly help their position, also points to a certain problem with respect to judicial revisitation of some of these aspects. And the judgment of Arun Kumar of the Madras High Court is actually in the teeth of the submissions being made here, which is to say narrow language being expanded through judicial interpretation contrary to legislative intent and history is to rewrite legislative history, and judicial reinscription, which is retrospective in nature, may not be exactly permissible. That's one. Then, Millards, the submission with respect to international law, all the general instruments apart, the Yogyakarta principle, specifically clause 24.e, specifically leaves it to countries to decide if they wish to have recognition with respect to marital unions. So it's not as if there is some kind of a binding precedent here, or there's no international instrument that says that you shall. I'm not arguing for it should not be. Kindly let this caveat is important. I'm simply saying if the door of judicial intervention in this matter is open for one case, even though the cause may be worthy, what does it do for the future? Because ultimately, it's not just a question of one matter. It's a question of the future as well. So therefore, there are specific aspects that relate to the issue in question, and there are general aspects that relate to the separation of powers and societal participation that go well beyond this matter. In light of this, my lords, my only humble submission is that there are other issues to be dealt with, and allow me to just point this out and use this particular forum to advocate only one aspect. Having actually engaged with certain transgender activists and also having worked with them, I know for a fact that one of the biggest problems is trafficking, them being pushed into prostitution, them not having legitimate livelihoods. I am not reducing or dismissing anybody's concerns with respect to what is their priority. Let me clarify that. I'm not making that submission at all. But these are certain Maslow's needs which have to be completed first and which have to be addressed first before we get to the next step. That's all I have to submit. I'm so grateful for the kind, please, great, deeply obliged.